talk more about laws. I know you've just read a whole bunch of laws and you've answered some questions, and that's awesome. But I thought we would jump right in, and I want to hit some of the really big key laws, just kind of mention them a little bit, and then also help you understand that we have some laws that are not included. I know the National CASA curriculum is about to be updated again, and therefore we're going to update some of these new laws. But this key laws that you see right here, the Child Abuse and Prevention Treatment Act, otherwise known as CAPTA, the Indian Child Welfare Act. Now, I will tell you, the Indian Child Welfare Act has been updated several times since 1978. It's been updated at least twice since I have been with the CASA program, and that was the summer of 2015. Therefore, I want to understand that just because this is the initial act, it doesn't mean that some of these laws haven't been updated. Now, you would have had the most recent updates except for the ICWA. The Indian Child Welfare Act has had some new things. The biggest key thing that is new about the Indian Child Welfare Act is now every child is considered to be an ICWA child until proven otherwise. This may slow the case down. This may cause issues in your local jurisdictions procedurally. However, that is the way the current national federal law reads. Adoption Assistance and Child Welfare Act, Adoption and Safe Families Act, Foster Care Independence Act, Fostering Connections and Success in Increasing Adoptions Act. Most of these times, these laws go by acronyms. These are all really, really crucial. However, it doesn't include a law that we've already talked about, and that is the Federal Family First legislation, which came in just a couple of years ago. This sets children to remain at home if there is just a risk. Risks can be managed. Safety cannot, and therefore we only remove children now if they have a safety issue that cannot be mitigated with a safety plan. The other thing is, if the child is removed, the agencies are absolutely obligated to place the child with a kinship placement. So that could be a family member, and that family member could be related or non-related. I know that, my husband was active duty military for a long time, actually well over 20 years until he retired. And we had families that were friends that our children would grow up, and they were closer with them than with our biological family, because our biological family lived so far away, and yet we saw some of the same people time and time again. If I was making that 3 o'clock in that morning and phone call and we needed help or something was going on with one of my children, those were the people that I knew that would drive 4.5, 5, 6, 8 hours to get to me and be able to make it there earlier. In fact, they would know the routines of my children and how to handle things way better than our biological family could, because they saw them much more often. They are considered non-related kin and will for the rest of our lives, even though my children are all up and grown adults now. So I want you to understand that that is to make sure that that child is in the least restrictive placement and the most comfortable placement possible, because we do not want to increase the trauma of a child. All right, we're going to talk more about that in later sessions, but I do want to make sure that we understand. Now, you're going to hear me refer to the Federal Family First legislation a few more times throughout the training, not all just today, but throughout the training, when it impacts and when things are different, because some of our cases that we do as our case studies would be different if that legislation had been in place. Now, remember, this curriculum was written in 2017, 2018. It was finalized. That is a long time ago, and things changed since then, as well as the fact that they would have collected these cases before from all over the country. So these cases are even older than that and would have gone under previous laws and not the most recent. So we're not done talking about laws. Sorry. Now, if you're a budding attorney, you are in seventh heaven with all this stuff. I understand. Now, the other law that this doesn't take into consideration that does have impact in our child in need of care cases, our SINC cases, is FERPA, the Family Educational Rights and Privacy Act. So this has to do with education. Okay, so how could this potentially matter? Like, how does this matter to us in a child in need of care case? Well, parents have rights to have access to the educational records of their children. Makes sense, right? However, what if we have removed a child from a home? And I will tell you, we have had cases where we worry about parents kidnapping their children and trying to avoid things like sometimes even criminal cases. And so they're trying to snatch their children and run. Well, unfortunately, that means that they cannot know where that child is placed. They may know generally what county, but they can't know the school or anything like that. Well, they also have a right to some educational information. So this is where we could have some potential issues. Now, most of these are handled and we don't have to worry about them in the court. However, we do need to make sure that we are aware. This may prevent or somehow restrict access to the parent's access to educational records. For instance, that child might have an IEP, an individualized education program. They might need some help with something. I have a granddaughter that has a learning disability. She's actually not just needing an IEP, she is actually, it's considered a 504 disability with her dyslexia because it is so severe. She needs extra help. She needs that individualized education program, and she's also disabled, so she has certain requirements that have to be met to help her read. She's actually a voracious reader, and as long as she gets the extra help, she will do really, really well. But what happens is that means on a regular basis, at least annually, that her parents have to go into the school, meet with the school team, and go over that new plan and update it as my granddaughter grows. Well, guess what? That's still the requirement, even if that child is a child in need of care in the foster care system. So if we have parents who don't know anything about the school or who aren't allowed to have access to the child at that moment for whatever reason, maybe they only have supervised visitation at that point in time, how do we handle that? And those are things that we need to be aware of with this law that could potentially impact child in need of care cases. Now, what I will tell you is typically they will make sure that parents can call in, and they will definitely not name the teacher or any of the staff there, and they won't name the name of the school, and that kind of puts protection in, whereas the parents can still participate, be aware, be invited to, but they cannot know information that they're not allowed, they don't have access to information that they're not allowed to know at that moment in time. So this is a law. Now, this is the other thing is it's not uncommon for us to, as volunteer advocates, to want to check up on grades or talk to the teacher, how's the child doing in class, or talk to the social worker at the school because the child may talk to them. How do you get access to that information? Because this federal legislation says, hey, only people that are supposed to have access to this information have access. Well, that is easy to do because you will have what is called a judicial counsel form. And I'm not going to show you a case of that right now, but it actually is something that is signed by the judge that appoints you specifically to this case and this child. And by doing that, lost everything for a second there. And by doing that, you are able to get access to those records because that has been signed by the judge for that child or that sibling group. And that helps. Now, you're going to potentially have to give the school a copy of it so that they know and different things like that. However, this is how you get access. You can look at attendance. How's attendance going? How are grades going? Are we having behavioral issues? There's a whole bunch of information we can gather about how that child is doing and we need to be able to report on this to the judge, so this gets us access. So, all right. I will also say that judicial counsel form also gets you access to their medical information. For HIPAA, it's not a HIPAA violation for you to have access to that. That is also covered on the judicial counsel form. Just thought I'd throw that in there, although I know we'll talk about it later. Okay, so let's talk a little bit about Kansas laws. Well, first of all, we know that they're called SINC, Child in Need of Care. We talked about the SINC process earlier in this training. We know that Kansas law states that all child needed care cases must start with reintegration first. Okay, now, we talked about the juvenile justice situation last week and everything like that. Some of our cases start with truancy. We have truancy is one of those things that really gives us a look. There's a variety of reasons why a child might be truant quite a bit. One, you may just have a child that's skipping school that has fallen in with a crowd not making the best decisions. It could also be that you have a parent or parents who are suffering from mental health disorders or who are dealing with addiction, and they are neglecting their children to the point where older children will watch younger children. This may mean they're skipping school because they've got to make sure that their younger sibling is on the bus, or that they work a part-time job to make sure that there's enough food for the younger kids to eat, or maybe that, the parent is out of it that day and there's a baby in the house, and if they go to school, they won't be able, nobody's taking care of the baby, and so they opt to stay home, or they run late, or they have to leave early to make things happen for their siblings. This is not uncommon. So a lot of times when we can see that there's a truancy case, there may be much more to it, and really what we need is a child in need of care case so that we can help with services in those families and help those families negotiate the challenges that they're facing. So, a couple of things. We've talked about listing cases and JV, and the other thing I want to talk about are code books. So, every year, laws get updated and changed, and different things happen. And they can happen both in the child needed care cases as well as the juvenile offender cases, and we have what we call code books. Now, here, as I record this, these are the most current code books that we have. Sometimes they have really pretty covers on them. I think they've gone with standard colors for a little bit just because it's less expensive and we're trying to save money. But you as a CASA volunteer advocate have access. You should have your own set every year. There's also a link where you can download a PDF version, and I know people that don't like paper actually kind of prefer those. So this one is the Juvenile Justice Code Book. You can see that it has all the laws and updates from 2023. These books come out somewhere between February and March of the year following. So every law, statute, every change that was made in 2023 is now held in this book, and there won't be a 2024 book until next year. And then this is the Child Needed Care book. And as you look through, I urge you to get these and read them, and I'm going to pull it up. And it is written by lawyers for lawyers and legislators for legislators. It will have, but it has, let me look at the, definitions of different terms. Jurisdiction, age of child, presumptions, parentage, fingerprints and photographs, pleadings, service of process, proof of service, continuances, rules of evidence, adjudication. Remember we talked about that earlier too. Reintegration, journal entry for child support, reintegration, rehearing, permanency hearings, change of placement, SINC placement in a juvenile detention facility. It handles a whole bunch. Any law that has to do with child needed care cases or juvenile offender cases is in here. So that is a good thing. These code books are amazing. I know that a lot of volunteers like having that copy because they like to highlight and write and make notes, and it helps them with their court reports. And these are made available to you every year. Sorry, have to take a sip with the tea. I actually don't like to talk a lot, which is why in these trainings it's a little more challenging for me because I do a lot of talking. Okay, so there are 7 core competencies for volunteer advocates that we are about to go over right now, and I'm going to briefly talk about this, then we're going to talk about it in our first meeting as well, our first video meeting. The CASA role, understanding your role. We kind of talked about that earlier. What can you do? What can't you do? That's a competency, understanding what your limitations are. I have stood up in court on behalf of volunteer advocates and said, hey, they cannot do that. That is outside of their role as a CASA volunteer, we are not authorized to do that, and the courts are always very appreciative when I do that because they don't always understand, because we really come in a collaborative in the 8th Judicial District. We really come in a collaborative mindset where we're trying to make things happen, and who can help facilitate this. And they have immense trust and faith in CASA advocates, and therefore they really want us on the team as much as possible. And sometimes they're asking us to do things that we cannot do. We cannot supervise visitations. We cannot transport children. These are absolute things that, as you read in your in the policies and procedures for CASA volunteer advocates in that handbook, that you know you cannot do. So, understanding that role. We don't expect you to know all of these right now. We don't expect you to understand what they all are. You may be better at some and some that are weaker. That's okay. That's okay. You're here to learn. So communication, being able to communicate with a wide variety of people, making sure you're choosing words that can be understood and understood appropriately. If we're talking about supervision, supervised visitation, what does that mean? You know, if I just think, oh, well, that means somebody can pop in and out at all the time. Nope, that's monitored visitation. Somebody has to physically be there. You know, those kind of definitions and different things like that. That's one type of way that we want to communicate, make sure we're all understanding the same thing. Cultural competence. We deal with a lot of cultures and subcultures and different things like that, and we want to be. Now, National CASA is looking at different words, but culturally aware, culturally competent, culturally sensitive. These are all terms meaning we need to be aware that other cultures have different ways of handling the same thing. Some cultures look straight in the eye when they're talking. Others, it's a form of disrespect to look someone straight in the eye, and therefore you should have your eyes down. Well, if you're looking down and you're in that culture and you won't make eye contact, someone from a different culture that does make a lot of direct eye contact might think, well, they were being pretty shifty. They were looking away and they weren't doing the verbal cues are different. And so we need to be aware and understanding and learning, because things are different and different things are valued more and less in different cultures and subcultures. So that's a whole piece of our training that we will get to later as well. Sound judgment. Well, I'm not talking about turning your sound up and down because the radio got loud. I'm talking about being able to make a good decision. What is in that child's best interest? And that comes with something, I'm going to skip over initiative for a second and go to foundations of knowledge. Having a really good foundations of knowledge, like this training, like the continuing education that you need to do every year, help you make sound decisions because you are better equipped, because you have more information to make a better decision. Now I'll go back to initiative. Once you complete training, where we kind of help you through it, a lot of this is on your own, but we're here a lot more and interacting, at least weekly and different things like that. When we move from this and you are doing the advocacy on your own, you're meeting with that child on your own time, and you're making sure you're meeting with them a couple of times a month at least and communicating with everybody. There's a lot of personal initiative that goes into that. Okay, I am not going to be the executive director or the volunteer supervisor that's constantly like, hey, did you make your phone calls this week? Hey, have you seen your child today? Hey, have you done this? No. There's a lot of initiative and a lot of trust that we place in you that you are going to do what you need to do without a lot of direct supervision. And then we come to the one, and I will tell you, this is the hardest one for me. This is the one where I'm always the weakest. I've been here long enough and been doing this for a really long time. And then I've been working with children-based charities for decades. Decades. But self-care. Self-care is tough for me. And that is one of the core competencies that you need, because you need